A Guide to Employee Copyright Law in South Africa. The Copyright Act regulates the ownership of copyrights, and the point of departure is that the author or co-authors of the work are vested with ownership of the copyright. The person who is regarded as the author depends on the type of work that was created, and additionally, the author must be an eligible person, which means either a South African citizen or an entity lawfully incorporated, and the work must be original and reduced to material form. Ownership and authorship are two different things, and Section 1 of the Act provides for who the author is in relation to certain types of works. For example, a literary, musical, or artistic work the author is regarded as that person who initially created the work. As for a broadcast, the author is the first broadcaster of that broadcast. If it is a published edition, the author is considered to be the publisher of the edition. And there are various others that are provided for by the Act. However, there do exist circumstances under which the default first ownership rule in favor of the author or co-authors of the work made may not apply, such as the case where a person is specifically employed to create the work. South African legislation provides for 3 cases wherein the commissioner of the work or the employer of the employee author is regarded as the first owner. Firstly, where a literary or artistic work is made by an author in the course of his employment by the proprietor of a newspaper, magazine, or similar periodical under a contract of service or apprenticeship, the proprietor shall be the owner of that copyright, unless the work is reproduced in non-recurring publications. Secondly, where a person commissions the taking of a photograph, the painting or drawing of a portrait, the making of a gravure, the making of a film, or the making of a sound recording, then that person, the commissioner, shall be the owner of the copyright subsisting therein. Thirdly, in the case of a work not falling under these 2 cases, and a work is made in the course and scope of an author's employment by another person under a contract of service or apprenticeship, that employer shall be the owner of the copyright. And thus the employer would be the owner of a copyright made by an employee if it is made in the course of his employment. The employer and the employee may, however, exclude the operation of this exception by making an agreement to this effect, and in which case the employee would be regarded as the owner of the copyright. Definitions of the various types of work can be found in Section 1 of the Act, and it's worthwhile going to the Act to see which category a specific piece of work falls under. The Labour Relations Act defines an employee to mean any person, excluding an independent contractor, who works for another person or for the state, and who receives or is entitled to receive any remuneration, and any other person who in any manner assists in carrying on or conducting the business of an employer. As we've already mentioned, Section 21(1) provides an exception to the default first ownership rule, which means that an employer is the owner of a work that is made in the course of the author's employment. So 2 things must be established here. Firstly, a contract of service, and the work must be done in the course of that employment. This may seem harsh, however, the reasoning behind this is as follows. Copyright plays an incentive function. Protectable works may be created in the corporate environment by persons who are employed specifically to do so. And here employers may reasonably expect to use the work free of any undue restraint to further their business. Should the first ownership of the copyright vest in the employee based on their authorship, the employer would need to acquire the rights to use the work from the employee, which results in unnecessary transaction costs and uncertainty. Further, the employer is the originator of the work and should be incentivized, since they would bear the prerogative and expense of the creation of the work, and as a result should be entitled to ownership of the copyright. Additionally, the employee's authorship of the work is as a result of the employment relationship, An incentive to the employee is given in the form of remuneration. Whether something was created in the course of employment was tackled by the Supreme Court of Appeal in King versus SA Weather Services. In the case, Mr. King was employed as a meteorological technical officer in charge of the South African Weather Service. During his employment, Mr. King created computer programs to assist him in performing his duties as an employee. But developing these programs was not explicitly part of his job description, since he was not employed as a software developer. And so the South African Weather Service then used these programs developed by Mr. King. Mr. King alleged that such development was not done in the course of his employment contract, since he developed it at home and outside of working hours. He claimed that he gave his employer a tacit license to use the software, but retained ownership of the copyright throughout, and thus the employer had infringed his copyright by continuing to use the program after Mr. King revoked the license to use. The crux of the matter was that if the software was developed in the course of his employment contract, the South African Weather Service, as the employer, would own the copyright. But if not, then Mr. King would be the owner. In its reasoning, the court held that the nature of the employee's business, the nature of the employee's duties, and the causa between the employment and the software developed, as well as objective facts of the matter, would be considered. And the court concluded that given the nature of the business was to collect, store, and process weather data, had Mr. King not been employed for this purpose, he would never have developed the software, which led to a finding that a software was developed in the course of his employment, and the owner of the copyright was found to be the South African Weather Service. So what this means is that there is no hard and fast rule to the meaning of in the course of employment, but factors such as the nature of the business, the nature of the employee's duties, the relationship between the employment and the work created, and objective facts of the matter will be considered. But at the very least, if the work would otherwise not have been created but for the employment relationship, the work will be seen to be made in the course of employment. Legislation has not provided a definition for an independent contractor, but the courts over the years have developed tests to assist in the determination of who an employee is and who an independent contractor is. The first test developed was the control test, where if a person is working under the control of another person, which could be proved by instructing the person doing the work as to time, place, or manner of how the work must be done, which would suggest an employment relationship. However, as society progressed, modern labor became more specialized, and the very nature of specialized labor suggests that employers who technically are not specialized exercise less actual control over employees. And secondly, even in an independent contractor relationship, the contractor still does exercise a measure of control over the independent contractor. The next test developed was the organization test, which looks to the extent that a person is integrated into the organization of another person, which may evidence an employment relationship, since an independent contractor is generally not integrated like an employee, but rather is an accessory to the organization. But again, problems arise with this test, as the extent of integration of a person may sometimes not be possible, may not possibly be determined, and nor is it clear as to the extent of integration needed to label one as an employee. The dominance impression test relies on various indicators to determine whether or not the dominant impression is that the relationship in question is one of employment or one of an independent contractor. And this is the test currently favored by our courts. And it must just be borne in mind that independent contractors are characterized by the fact that one person hires another person to do a specific job or a specific piece of work. Factors indicating an independent contractor relationship can include the employer having no rights of supervision, the worker does not depend on the employer to perform his duties, the worker is entitled to take up other work, the worker has freedom in regard to working hours, and may subcontract for the performance of duties. The worker may be paid by a commission as opposed to a fixed rate. The worker may use their own tools and equipment, and the employee may not discipline the worker. Take this example and decide whether this relationship is one of an employee or an independent contractor. On 1 January 2022, an agreement is entered into between X and company ABC. The agreement stipulates that every workday morning, X has to arrive at ABC's factory, where a truck will be waiting. At this time, he'll be informed of where to pick up different bins of jeans, and at the same time, he'll be provided a route to take, which may not be deviated from. Upon arrival at the factory, X must submit an inventory list from the previous day's work. And each Friday morning, X is required to fill up the petrol tank of the truck at a prescribed garage using a company credit card, and a receipt must be kept and handed back into the company. X is remunerated on a monthly basis at a rate of R1 per pair of jeans checked. X is responsible for the arrangement of their own tax affairs, pension fund, and medical aid, and no deduction in relation to these matters will be taken from X's remuneration. X is further free to do alternative work on the weekends and on days where he finishes early. The company further reserves the right to cancel the contract prior to the expiry date should X be in breach of contract. So after applying the dominant impression test, while there are weighty factors suggesting that X could be an independent contractor, such as remaining responsible for their own tax affairs, medical aid and pension fund, and that X may perform alternative work for other companies. However, more factors indicate that X is an employee. These factors being a specific truck is used to pick up the garments, there's a prescribed route of pickup, there's a need for proof of the previous day's work, the level of integration by requiring X to fill up the tanks on the company's account, the method of remuneration, and the fact that the employer has the right to dismiss X due to misconduct. The Section 21 exception only applies to the employment relationship and not to independent contractors. Copyright ownership by an independent contractor is ideally regulated through an agreement between the relevant parties, but should there be no agreement to this effect, then the default position would apply, and the independent contractor retains ownership of the intellectual property developed by him or her. In such a case, the employer of the independent contractor is then generally entitled to an implied right to use the intellectual property for purposes that are reasonably foreseen and understood by the parties.